got two videos. We're going to talk about specifically security interests and liens in finance companies' names. And the first video, we're going to talk about the obligation of the dealer when they sell a contract out to a finance company. And in that regard, I'm talking about specifically the security interest and making sure the lien is recorded. Most dealer agreements, I'm trying to think here if I've seen one that says otherwise. I can't think of one that I've seen otherwise. But I never want to say in absolutes that all of them have this, but most dealer agreements require the dealer, when they're selling a contract over to the finance company, to provide a warranty or a representation of the finance company that the dealer is going to ensure that the finance company's lien is recorded on the title. Now that becomes a mess when, like we said in a previous video a little while back, the dealer is unable to register the title because they don't have it from auction, or for a handful of whatever reasons they make a mistake internally, a new hire messes up, who knows, right? What could happen when registering titles? Well, that becomes a huge issue when the contract is sold over to the finance company, because the finance company, now you've got two fronts, right? The dealer has a two-front battle. One is the customer who doesn't have a title, can't get a tag, technically when the temporary tag expires, can't drive the car. And then there's the finance company that's already paid the dealer for the deal and is not secured. Their interest is not secured on the car. So let's say the car gets in a wreck, right? The finance company doesn't have a lien. They have no security. Let's say the customer defaults. The finance company's not able to repo because they don't have a lien, because the dealer hasn't put one on there. And so, any dealer can see very quickly this can become a very, very big problem, having both sides, the customer and the finance company, coming at the dealer at the same time. So it's just another example of when it's critically important to follow the reps and warranties of the finance company's agreement and really attack these things head on. If the title is not going to come, if there are issues with the title, it's best to be upfront and notify the finance company, hey, this is what's happening. Don't hide behind it. Almost every time I've seen a dealer try and hide and keep saying things like, it's gonna happen, I'm working on it, we're getting it, sorry for the delay. Yeah, maybe that buys a little bit of time, but in the long run, it very rarely works out unless, of course, the title is provided. And even then, it doesn't necessarily remedy the situation. So just because the title eventually comes, the finance company still has a right in many cases to demand repurchase. So it's something that just to be aware of for dealers, that just because you get the title, if it's late, if there's a violation of a representation and warranty in the finance company dealer agreement, then the finance company still may have the right to demand repurchase of that account. Now in the next video, we're going to talk about a case study dealing with liens. This is something that I've come across specifically in practicing law for dealers, and it's a very interesting issue. Hang tight and stay tuned.